believe we shall overcome someday. You're right, who said we'll die someday? Deep in my heart, I do believe who said we'll die someday. That we'll die someday.
Captain Venezuela.
For the applicant, and the response is in court. Your worship, to request my senior colleague, the yes, for
Please.
Your Worship, we have gotten instructions to raise a complaint against you before the Judicial Service Commission. On grounds of maladministration of justice, incompetence, and abuse of a judicial office. Your Worship, complaint which is already filed before the Judicial Service Commission is here for record purposes. Substantiate the accused or the respondents in this matter have gotten reasonable fear and apprehension that we will not have the requisite competence to adjudicate a matter of this nature and to dispense justice, considering the antecedents and the proceedings that have happened before. First of all, the propriety of these proceedings, Your Worship, being manifestly unconstitutional. The last time the matter appeared here, the state indicated that they had finalized all the investigations they wanted to conduct and proceeded with the control proceedings. Your Worship. Under Section 168 of the Magistrate Court Act, Your Worship, this Honorable Court ceases to have jurisdiction over a matter that is triable by the High Court upon conclusion of the pre-trial processes. Once the state has summed up its case, prepared the committal papers, and the file is forwarded to the High Court for purposes of trial. This honorable court is deemed to have exhausted its jurisdiction and has no residual powers whatsoever to handle any interlocutor application like this court is purporting to do. It's the first of its kind. If I may bring myself into the picture of the proceedings. In my 28-year practice, I have never witnessed such kind of proceedings. And I'm sure many lawyers will attest to this fact, including judicial officers, that after top proceedings are done, that there can be any other application to be entertained by the Chief Magistrate, whose jurisdiction is restricted to pre-trial processes. It's on that basis that the respondents here are convinced that Your Worship that you have demonstrated gross incompetence in managing the matter, this magnitude, with a grave offense that has reaching implications as far as their lives are concerned, which carries a death sentence. Now, a matter that carries a death sentence means problem. Is the failure by this honorable court to comply with the dictates of the Constitution under Article 23 and Section 76 of the Constitution, rather of the Magistrate's Court Act, which provisions were cited before you, Your Worship, and they are couched in mandatory terms. That once an accused person has logged 180 days before conduct, they are entitled to mandatory pay. And this honorable court cannot conduct any other business apart from addressing itself with the question of martial law. And the practice guideline is what now want to be in Your Worship, particularly guideline number 10.2, paragraph 2, which requires you, if you decline to grant mandatory pay, to forward the matter file to High Court for that particular purpose. Your Worship, you do not pronounce yourself on the question of whether the accused persons have spent more than 180 days of remand or not. You have never ruled on that matter. You have never made any ruling. In which case, you will proceed to determine whether they are entitled to mandatory pay or not. If you find that actually you lack the requisite jurisdiction because of the impartiality practice guideline, yes, you fall back on that guideline 10 and forward the file of High Court. That was never done. That is also considered as an act of gross incompetence. Your Worship, the applicants are relying on the authorities Attorney General of the Republic of Kenya, the applicant, versus Professor Anyangunyo. This is an East African case. It's the East African Court of Justice at Arusha, application number 5 of 2007. Their lordships had this to say, that for the purposes of the application for recusal, we do not find it necessary to the objective test of reasonable apprehension of bias is good law. The test is stated various